I would like to divide today's webinar into three parts. First, to tell you a little bit about what is happening here in Israel and how the country is functioning. Second, to analyze the current crisis in the Middle East and focus on its business and legal implications arising from the regional conflict. And third, to have an open discussion with questions and answers. And as always, we say in Israel these days, if there is a siren during the webinar, we'll take a break of 10 to 15 minutes and then continue from the same point. So let me begin with the first part and tell you a little bit about what is happening here over the last 20 days and from a personal view over the last 24 hours. First of all, on the personal level. Yesterday, I was taught 9 hours in 3 different courses, all in Zoom. The second semester has started in the universities, so everything is taking place on Zoom. At home, my children are on Zoom as students in high-tech studies, and I am on Zoom as a law professor. And few times in the middle of the classes yesterday, there were sirens. So we went down to the shelter, met there, and then came back and continued the lectures. Last night, we woke up 3 times in the middle of our sleep because of warnings about missile attacks, sirens, and we went down to the shelter. On the way to the office this morning, there was another warning about a missile attack, so I returned to my house for the shelter. Just as I was about to arrive at the office, there was another warning, so I met my team in the shelter. Today we held 3 arbitration hearings in the office in person, while the arbitrators and the parties went down to the shelter each time there was a siren. But we continue. And now a few words about what is happening in the country. First of all, regarding the missiles. Since the beginning of the war, 20 days ago, Israel has been attacked day and night by hundreds of ballistic missiles and hundreds of drones and suicide drones. It is a crazy situation. Any normal person would probably not stay even one moment in such a country. And yet, you may be surprised to hear that tens of thousands of Israelis have been trying to return to Israel since the war began. So maybe we are not normal, but there are several important facts that make Israel different from almost any other country in the world. I will start with the defense and protective measures. First, every person in the country receives a warning on their mobile phone before a missile attack. Israel detects missile launches from Iran by radar and warns the public that ballistic missiles are on the way. That gives us around 5 minutes to prepare and go to the shelter. Second, as a siren comes telling us we must go into the shelter. The siren is heard both through outdoor loudspeakers and through mobile alerts. Usually after a minute or 2, we hear explosions in the air, which usually means that the missiles has been intercepted. Third, there is a siren. We enter the shelters. In Israel, every building constructed during the last 40 years has a protected room in every apartment. It is a room inside the apartment, which with thick reinforced concrete walls and a special secure structure. In our older buildings, there is a communal shelter in the basement underground. And in buildings older than 60 years, there are public shelters, and municipalities place protected units throughout the city. The basic idea that everyone should be able to reach a protected place within a reasonable time. And fourth, Israel has the best air defense systems in the world, both outside the atmosphere and at a lower altitude, able to detect and intercept threats against the civilians. So the result is amazing. Over is 100% of drones and suicide aircraft launched from Iran were intercepted before reaching Israel, 100%. Around 98% of the ballistic missiles were intercepted either outside the atmosphere or in the air. Now, sadly, we have 17 people killed so far, but considering the huge number of missiles attacks and their enormous destructive power, it is truly a great miracle. Let me tell you that on the second day of the war, a missile hit Tel Aviv, about 200 meters from here. It was a direct hit on an old building. The entire building collapsed, and all the glass of the entrance of this building, which belongs to the Israeli Chamber of Commerce, was completely shattered. There was damages to the offices inside the building, and even in our offices at the Israeli Institute of Commercial Arbitration, the IICA, the acoustic ceiling and wall panels collapsed. And just for you to understand, there are no windows facing the side of where the missile fell. So you just can't imagine the power of the blast when shop windows within radius of hundreds of meters were shattered. And I can tell you, I cannot imagine how Tel Aviv would look like without these air defense systems when hundreds of deadly ballistic missiles are exploding here in Tel Aviv. And the importance of the advance warning and the shelters. In these strikes that I'm telling you in Tel Aviv, with 1 ton of explosives, which completely destroyed one building and damaged dozens of buildings, the surrounding buildings, we would have expected dozens of people to be killed or injured, but in practice, the people went down to the shelter in time, and almost everyone survived, except for one disabled woman who could not get down quickly enough, and her caregiver from the Philippines who stayed with her in the apartment. And both were killed by the missile. And yesterday in Ramat Gan, an elderly couple they were on the way to the shelter, but they did not manage to reach it on time, and they were killed by the missile strike. So this is what we are having in terms of the attacks and the situation. Now about the situation in Israel in general. Most businesses in Israel are functioning. I cannot say all shops are full of people, but absolutely not. But businesses are working. Many people are working from home. My children work in high tech and working from home full day from the first day of the war. One advantage is that there are no traffic jams, which is good. There is no shortage of food or products in the stores, and this is not something to take for granted. I must say that during the periods of COVID, wars, other emergencies, the supermarkets here have always been full, including fresh products like dairy, fruits, vegetables, and so on. So those who want can go physically to the stores, and those who prefer can order through the various apps by their smartphone. Schools are closed, children are at home, studying on Zoom, even from the age of 3. The courts are currently closed and operating only in a limited emergency format. As for the Israeli Institute of Commercial Arbitration, the IICA, when the war began, I announced that we would cancel activity during the first week because of the home front command instruction. From the second week, the instructions allowed work to continue. And since then, we have been working at full pace. As I said, just today, we held 3 arbitration hearings. One of the arbitrators is here, Ronen, is here, and I met him in the shelter. I'm handling these days 2 large-scale arbitration cases. In both cases, the parties approached me and asked that despite the war, I should continue the proceedings efficiently, just as we had done before, and this is exactly what I'm doing. So, as you understand, war or regional conflict is not just a headline in the news. Very quickly, it reaches businesses, contracts, supply chains, timetables, and the very practical question is, who bears the risk? And what do we do when things no longer go according to the plan? And this brings me to the second part of the webinar, the impact of the conflict on business and law. I do not intend to speak today only on the theoretical level. I want to touch on the practical side, on the approach of the Israeli law, on the importance of good contractual drafting, and also on what happens to arbitration proceedings precisely in times like this when the reality around us is far from normal. The first point is this. Conflict is not only a political or military reality, it is also a commercial and legal reality. The moment there is instability in the region, practical consequences appear immediately. Flights are cancelled or delayed, transport routes change, employees might not be available, suppliers have difficulty meeting deadlines, and the parties to transactions find themselves asking, is it still possible to perform the contract as originally agreed? In other words, the dispute does not begin in court or in arbitration. It begins much earlier, at the moment when reality changes, but the contract remains the same. And here is it is important to remember, businesses need certainty. They can deal with difficulty, with higher cost, with commercial inconvenience. What they find much harder to deal is uncertainty. So in times like this, the key legal question is not only what happened, but what did the parties agreed in advance would happen if it happened? And that is a classic contractual law question. The second point is what happens to contracts during a time of conflict? When we look at the impact of conflict on contracts, I think we can see several recurring patterns. Sometimes it is a matter of delay. The contract is still possible, but not at the agreed timetable. Sometimes it is a matter of higher costs. Performance is possible, but much more expensive. Sometimes it is a partial performance. And sometimes, of course, the argument is more serious. Not only that the performance has been more difficult, but that it has become impossible or fundamentally different from what the parties originally agreed. This is exactly where the legal problem begins. Because not every difficulty and not every increase in cost is force majeure. And not every change in circumstances releases a party from the contract. This is, in my view, one of the most important points in the whole discussion. The business world sometimes likes to think in broad terms. There is a war, so perhaps a contract is simply on hold. But the law, usually much more careful. The law asks, was performance really prevented? Could the event really not have been foreseen? Could it not have been overcome by reasonable means? And it is truly a fundamental change rather than just a major commercial difficulty. And this brings me to the heart of the legal analysis. at least from the Israeli perspective. Does Israeli law really allow parties to escape a contract easily in times like this, in conflict, in war? And in my opinion, the answer is quite clear: no. One of the main points I want to emphasize is that in Israel, the idea of contractual frustration, in the sense of a real and easy possibility of being released from the performance of a contract, almost does not exist in the broad way that people sometimes imagine. To put it simple, Israeli law adopted the English approach that contracts must be performed. Therefore, the law does not allow parties to be easily released from their contractual obligations. To reach the level of frustration, the standard is high. And here I think there is an interesting point of similarity between Israel and English law. There is emphasis on contractual certainty. There is emphasis on keeping contractual commitments. And there is a great caution against giving parties too broad an excuse not to perform just because reality has changed. And in my view, this is an important message for the business world, because sometimes it seems that in a region like ours, where conflict, tension, security risk, and disruptions are part of life, one could always say afterwards, we did not foresee it, we didn't know, we could not perform. But especially in a region like this, courts and also commercial and legal community tend to say, ladies and gentlemen, in the Middle East, one must think in advance about scenarios of instability. And therefore, on the practical level, Israel creates quite a high degree of contractual certainty. It is not easy to escape a contract. The default rule is that contracts must be performed. And if we cannot rely on the law to release party easily from the contract, then the natural question is, what is the solution? And in my opinion, the answer is the contractual drafting from the beginning is intended to decide and to deal with this situation. The term force majeure sometimes sounds like a big and dramatic phrase, but in the contractual world, it should not be dramatic. It should be mechanism for allocating risk. Mechanism for allocating risk, especially in our region, because in the Middle East, periods of crisis and tension are part of life, and therefore a force majeure clause should be a real and serious mechanism of allocating risks. I suggest thinking about such a clause through several simple questions. First, what is the covered event? Is it only full-scale war, a global pandemic? Second, what should be the legal effect on the event? Is it enough that performance should be legal, should be the legal effect of the event? Or is it necessary that performance is actually prevented? That is a very significant difference. Third, what is the duty of the affected party? Must that party try to find an alternative solution, another supplier, partial performance, a reasonable extension of time? This is too an important point. And fourth, what is the result? Is there a suspension? Is there an extension of time? Is there cost sharing? And in my view, this is perhaps the most important question of all. Not only whether there is force majeure, but how the parties allocate between themselves the risk of force majeure in advance. And my message here is simple. Especially in transaction involving Middle Eastern countries, and we're talking about at least 12 to 15 countries involved in this war. It is very important to include such a clause in the contract and define its consequences in advance instead of leaving everything for a later argument. So far, I have spoken mainly about the substantial level, what happens to contracts, what the law says, and why it is so important to draft force majeure clauses carefully. But there is another important question. What happens when the dispute has already begun? How do we conduct proceedings in such a period? And here is what I want to say, something in a very simple and direct way. For an audience of arbitration professionals, I do not need to explain why arbitration is a good mechanism for dispute resolution. We all know very well the advantages, the flexibility, the professionalism, and the value of the process. So the point I want to emphasize is not why arbitration is good. The point is something else. That even in times of war, or of sirens and of uncertainties, arbitration proceedings continue. In our institutions, the IICA, hearings are taking place each and every day. Cases are moving forward. We work in person, we work on Zoom, and we continue to provide parties with a live, active, and continuous procedural framework. That says something about resilience, about stability, and about the responsibility we have as an arbitration community, even in difficult days. And because in the end, businesses in the middle of a crisis need a framework that works, a framework they can rely on, a framework that continues to function even when everything around is unstable. And in my view, in such periods, procedural community is itself a value. And from here, I would like to connect the two main lines of thought I have discussed today, and I will finish with this. The first is the contractual line. The second is the procedural line. I believe that in times like this, the commercial world needs two things more than ever. The first is substantive certainty. That means understanding that the contract is still a binding document and that not every crisis cancels it. This is very important for the stability of commerce and investments. The second is procedural certainty. That means knowing that if a dispute does arise, there is a professional, continuous functioning framework that parties can turn to and use in order to move towards a solution. And in that sense, good constructual drafting and an experienced professional arbitration institution complement each other. And therefore, in my opinion, one of the most important messages of this period is this. It is necessary to build in advance both the contract and the dispute resolution mechanism. And I'm proud to lead an international arbitration institution that continues to work and function at full strength, even during such a stormy and challenging period. In my view, that is a large part of our role as arbitration professionals. And I thank you very much for listening. And I will now be happy to move to the third part of questions, comments, and open discussion. So go ahead, I'm here.
Hi, Menashe. If I wish just thank
Yes.
you for
Yeah,
the
yeah.
things, and we are sharing the same experiences. We are living in the same Tel Aviv and need to suffer the same risks. I would like to add a comment and maybe ask for the input of the other listeners and yourself, of course. Uh, During such tension, there is a very important factor of uh, lack of information, and the fragility of the situation is such that a decision or certain emotions that you serve in a current point in time can be very different a week or 2 weeks after. I'll give an example. When the war started 2 weeks ago, the market stopped. There was minutes that we wanted to know where it goes to. And as an arbitrator in the institutions that you are heading, I had to make a ruling regarding timetables that parties need to serve their summaries, for example. And 2 weeks after, when we see that the situation is stable under all the events that you clearly mentioned, it can be a different decision, regardless the fact that we are living still under war risk, and there is a way to look at the things differently. And my question to you, do you see uh, I would say, a difference between types of decisions, like the ones that relate to timetable that the arbitration need to take place, in compared to more substantial decisions which are getting into the merits of the arguments of the parties. Is such a such a distinction will be valid in the point of view of the parties and their rights in compare?
I tell you, it's a very good question. I just needed to deal with such an issue today when one of the councils asked for example, we have an option of appeal in the IICA. We were the first to have it under our rules if parties agreed in advance about an appeal. If not, the default is no appeal. But they asked for appeal, and he asked for to make it a little bit longer because of the war and because courts are closed. So I told him, listen, if you give me some good reasons why to have an extension of time, it's okay. But just because courts are closed, this is not a good reason, because we are arbitration institution and we work, and
Mhm.
that's the service we need to provide for the party. So if you have a very special argument why to, it's okay. I can consider it, but not in any case. So, and talking about hearings, we have hearings here. I know that many of the arbitrators are working now, and many of my judge friends are working now on they working and writing their their arbitral awards or the judgments because they have more time maybe. But we're dealing in exactly the same way, unless there is a good reason why not. So I wouldn't differentiate unless there is a good reason. If there is a good reason, I go with it. Of course, we're in a time of war, we need to be more considerate. But as I told you, and my whole construction of thinking is that we need to provide service, and that's what we're doing. And we're different from court. That's arbitration.
Mhm.
Anyone
Absolutely.
else? Yeah. Thank you, Henri. And yes, we were talking even today about
Sure.
uh, yeah, it's good. Uh, yeah, Shai is very quiet. I don't know what happened to him. Usually he has to speak, but today it's very quiet. Uh, and Ronen, if you want to say something, because Ronen, for example, had arbitration today, hearing here. He wanted, even the first week when our offices were closed, he wanted to have an arbitration here. I said, no, no, listen. So he said, I'll do it in Zoom. I said, okay, if all the parties agrees to do it in Zoom, it's okay. But not here, because the offices were the first week were closed according to the army instructions. So, but it's okay. If there are any other questions, I'm ready here to answer. Yes, please. Very much. Yes. I don't hear you. Please, if you, yeah, maybe you're in.
Hello, are you able
Yes.
to hear me now?
Yeah, yeah, sure. Go ahead.
Thanks from India to all of the listeners and to you. Right at the beginning, I must compliment Israel for its resilience, like you mentioned.
Thank
There
you.
are endless stories of how you all have survived in times of crisis. And this is just one of them. When you say it is a part of life, I can imagine how it is imbibed in your way of life. And I must compliment all of you for that.
Thank you very much.
One small question. I am, like I told, I'm studying now to become an arbitrator with something called the Indian Institute of Arbitration and Mediation in India. And they have an online dispute resolution platform. So for that, it is called the official ODR platform, which is an AI generated tool, and all your documents and hearings are uh, documented there and preserved there. So, does the Israeli center also have their own platform, or Zoom is considered sufficient? Because Zoom is only a conferencing platform.
I can tell you, for example, during COVID times, first of all, you know, Israel is a technological country, and
Yes.
we had all the online dispute, online dispute ODR mechanisms even before COVID. But during COVID, for example, that we're not allowed to meet, we had Zoom arbitral proceedings, uh, even hearings with witnesses and everything, because we had actually no we had otherwise we would close display, so we had to do it on Zoom. And for us, it's okay. Like if the parties are good with it and the arbitrators is okay with it, so we can have in Zoom, for example, talking about in war times when people are has to be at home with children or something like that. Even there are witnesses or counsels, they can be on Zoom, and it's not a problem at all. And yes, we work with India. Just one day before our strike in Iran, I had the great honor to be with your Prime Minister Modi and our Prime Minister Netanyahu signing an MOU with the Indian Arbitration Institution and the IICA. So it was a great honor, and I believe there is a great, let's say, future for the Israeli and the Indian legal community.
That
Shai,
is,
yes, I was waiting for you because usually you're not quiet. What
Yeah,
happened? Yeah.
thank
I'm
you.
good. Sorry, I'm good. I just don't have the camera with me. It doesn't work, so apologies for not turning it on. So I want to comment on two aspects of what you discussed. First of all, on the merit on oh, we have an alert. Um,
Really?
yeah,
It's good. You see, we
yeah.
have an alert. We need to go. If you
This is
want, I can,
this is like a live example of
Red,
yeah.
red light.
And if
yeah.
you want, those who are overseas, I can connect you and you see it online how it works here. We will go soon to the shelter. So those of you wish we can stop here. Those of you wish we can continue on and you will see it. And Shah, you see, you just open your
Yeah.
mouth, look what happened.
I should have stayed quiet. Uh,
You can't.
so so I think on the merits, I would say Israel has a very interesting approach, which is a bit different than in some states, in some countries, because there are states where the relevant doctrine for force majeure is frustration of of contract. And Israel, by large, is not following that doctrine. In some cases, if the contract is really explicit on this issue, then probably yes. But in others, if the contract is still executable, the courts will not allow to terminate the agreement. What they will do, and this is something that I'm not familiar with other jurisdictions that follow the same line, they will reevaluate in some cases the value of the contract. After COVID, when the shipping prices and the commodities prices spiked, there were a lot of disputes relating to infrastructure projects and construction projects in Israel, where the court said, you know what, we're not going to allow you to terminate it, but we're going to change the consideration in a manner that would be, I would say, fair to the parties. And that is a unique approach that I'm not familiar with any other jurisdiction where it is applied as the general rule. So that's the first thing. The second thing,
but please quickly, because in one minute we will need to go.
One sentence, and this relates to the last question. So there is no dedicated online platform for virtual hearings in Israel. Usually we use the international platforms such as Opus and others, but we are doing online hearings, day in and day out. So it's not something special or unique just for this specific situation, but it's something that has become, to an extent, quite the norm now. So that's.
Thank you, Shai, for your important comments. We will leave now to the shelter, and thank you very much for your participation. It was a great honor, and have a good evening and good news to all of us. Thank you very much.